Good morning, everyone. I'm Susan Bocamazzo. I'm the publisher at Massachusetts Lawyers Weekly, and thank you for joining us for our program on succession planning for lawyers, where our panelists will be discussing how to value a lawyer's practice, succession planning options for lawyers, and when a lawyer can afford to retire, even during the COVID-19 era. A few matters to start. First, I'd like to thank the sponsors of today's program, Senior Attorney Match and 12 Points Wealth Management. Second, our presentation is being recorded, and you'll receive a copy of that recording by email later today or tomorrow. Third, we will be taking questions at the end of the program, so please add your questions to the chat at any time during the presentation. Now, let's meet our speakers. Attorney Jeremy Poock is the founder of Senior Attorney Match, which designs and implements succession plans for attorneys who have practiced for 30 years or more. Jeremy founded Senior Attorney Match in 2013 after focusing on business law as a Massachusetts attorney. Senior Attorney Match works with senior attorneys nationwide who practice in a variety of practice areas. As Jeremy says, if you have clients and referral sources, your practice presents value to the right successor. Attorney Chris Cahill of 12 Points Wealth Management in Boston runs the firm's family office services practice. Chris is a certified financial practice planner and a chartered advisor in philanthropy. With over 15 years of experience in financial consulting, Chris specializes in assisting lawyers in all aspects of their wealth management needs. His unique combination of skill sets allows him to focus on financial planning strategies, estate planning, charitable planning, succession planning, and portfolio management to help his clients achieve their specific long-term planning objectives. Chris also works with law firms to develop and implement appropriate retirement plan programs, risk management programs, and succession plans. While his clients are located throughout the country, Chris has developed a particular following in the Northeast, New York City, and Washington, D.C. And now I'm going to turn the program over to Chris and Jeremy.
Thank you so much, Susan. We really appreciate it. And good morning, everyone. On behalf of 12 Points Wealth Management and Senior Attorney Match, we're very honored to be here presenting to you today. We know that you have a lot of opportunities to be doing other things this morning, and we're truly honored that you're spending time with us today. Right, Jeremy?
Yeah, thank you very much. And big thanks to Mass Lawyers Weekly for hosting this webinar. We look forward to spending the next hour or so with everyone who's joined to address these questions of how do you value your law practice and when can you actually retire.
Excellent. And Jeremy, I think it'd be important for the participants here to understand a little bit more about you as a person. What brought you to start Senior Attorney Match? Obviously, you're an attorney and you practice, but what was the journey to get you where you are today?
Sure. Thanks a lot, Chris. So I am a Massachusetts attorney and spent the first part of my legal career focusing on business law. As a sort of natural born entrepreneur, I gravitated to business brokers and assisting business brokers with representing buyers and sellers of primarily small Main Street type businesses. And then recognized that as business brokers are focusing and will continue to focus on baby boomers, that they weren't brokering law firm sales. And that really was a light bulb moment for me back in circa 2011, 2012, and then launched Senior Attorney Match in 2013. And as Susan said in her opening remarks, what Senior Attorney Match does is we design and we implement succession plans for lawyers, and we'll be getting much more into that throughout the course of today's webinar. How about yourself, Chris? Please, a few introductory remarks from you, and then we'll jump right into it.
Excellent. Thank you. So I practiced law myself in Boston for a number of years back in the late 90s. Candidly, I did not love the practice of law, and I moved into the world of financial services. I worked at a big insurance company doing their estate planning, all manner of financial planning, estate planning, and succession planning for very, very wealthy families. And I transitioned out of that back in 2009 to work directly with clients on their personal financial planning needs and objectives. And through that time period, it was pretty clear to me that the attorneys that I knew were really struggling with planning appropriately for their own wealth and getting to the end zone and getting into a successful and through a successful retirement period. So for me, it was pretty clear that that was a good marketplace for me to focus my efforts on. Having practiced law as long as I did, I really understood what made lawyers tick, and I knew that there was a need for it. So At 12 points, as Susan indicated, I run the Family Office Services Practice Group and work with primarily lawyers and law firms in all manner of their wealth management, their succession planning. And I'm really excited to be here today and walk through these case studies with all of you and hopefully generate some really interesting dialogue and conversation. So without further ado, Jeremy, why don't we get into the fact pattern here that we're looking at?
For sure. So we're going to introduce everyone to attorney Bill Turner. And attorney Bill Turner runs the Turner Law Firm. And by the way, just one housekeeping matter, please feel free to put your questions in the chat, and we'll be monitoring the questions and answering the questions towards the end of the program. So attorney Bill Turner runs Turner Law, has 2 associates with him, and has 3 support staff. It's primarily a transactional-based firm focusing on business law, real estate with no conveyancing, and trust in estates. The total gross revenues for Turner Law, and Bill Turner, we're assuming, is 67 years old, ideally wants to start slowing down at age 70 and really wants to be able to retire by age 72. Turner Law, again, has gross revenues of about $1 million a year. Attorney Turner himself bills out at $400 an hour. I'm sorry, at $350 an hour. And his total billable hours in a given year are circa 1,100. You'll see there precisely 1,143, which comes out to his billings being at about $400,000 a year. His 2 associates, they bill out at a lesser hourly rate at $300 an hour. And they are billing about 1,000 billable hours a year. He would love it to be more. It's just in reality, that's how many hours the associates wind up billing out per year. The overhead for Turner Law is about $600,000. Net profit in terms of what attorney Turner is able to take home before taxes is $400,000 a year. And then just a few other points about attorney Turner and his practice is that he's still working 5 days a week, often coming in on the weekends. And his longest vacation, which I hear about often with senior attorneys that we work with, has been no longer than 2 weeks. And that's been for really the last 30 years. Attorney Turner is typically referring out somewhere between $25,000 to $50,000 a year. And similar to many attorneys that refer work out, he's not getting any referral fees for that work that he sends out. And Chris, let's take a peek at what the Turner family's financial situation looks like at this point.
Yeah, certainly. So this is a pretty typical fact pattern of a solo small shop attorney in and around the Northeast area. As Jeremy indicated, 65 years old. We'll assume that they're both 65. We run our financial models through age 95. If there's family longevity that takes that out past that, we can easily do that. But we'd like to target that neighborhood there. But we're looking at retirement assets, 401ks, IRAs, et cetera, of around 1.2 million currently. Other taxable assets in an investment account of around 300,000. And for purposes of modeling, we've just assumed a real traditional plain vanilla 60-40 stock bond portfolio, which is what we see many folks with these days. And as it relates to most attorneys that we work with, the biggest question and the biggest issue is cash flow needs. So here we've got their basic living expenses at around $105,000 a year. That's after tax expenses for Bill and Lisa. They, like many folks locally here, are providing financial assistance to their family, their children, grandkids, etc., to the tune of around $20,000 a year. Health insurance costs about $10,000. They like to travel. They liked to travel before COVID. Hopefully they plan on traveling again. And then there's some charitable inclinations as well. So all told, living expenses of around $150,000 a year. And that's what they really need to be able to amass assets by retirement to maintain their standard of living throughout the balance of their retirement, which will be, 30 years, give or take. So, we look at it and say, right now you've got around $1.5 million based upon the financial models that we're going to review momentarily in order to have a real high probability of success and be able to retire at approximately age 72 the Turners are going to need to amass approximately almost $3 million of assets to maintain that standard of living going forward. Because again, remember, those numbers, that 150 is being inflated. And, obviously there's things like health insurance that are going to inflate typically faster than the normal inflation cost. So we build all of that into these models, and we really try to go above and beyond to stress test them and put as much pressure on them as we can to make sure that we're focusing on where the risks and potential pitfalls are in the modeling. So Jeremy, let's take a look at the success, how we determine success here. So for the Turners, you're going to see throughout the models momentarily probabilities of success. And this is really all premised upon Monte Carlo scenarios and Monte Carlo analyses that we do with our plans. And what that means is we'll take each of these plans and run it through 1,000 trials, providing excellent return opportunities and poor return opportunities in the investments and all other manners of the models. And it's going to generate probabilities that are either going to be what we call below confidence zone, under 75% probability of success, or in the confidence zone here where we see that they have good probability of success, 75 to 90%, and then certainly above the confidence zone. So there are models here that show them with above confidence zone probability. And that means that, they are in a really good position and could potentially do other things, either spend more, give away more, or work less. So looking at these scenarios, it really this is a guidepost to making decisions, an informed, smart decision with your wealth going forward is really the way we look at it.
Great. And then in the next slide, one of the themes of our webinar today is how do you value a law practice? So let's just think back to just a few minutes ago when Chris introduced the Turner family to us, and we see that currently they have $1.5 million as their total wealth, and they need to get to $2.8 million. We already heard that Attorney Turner has a law practice that generates about $1 million a year. And so if Attorney Turner came to Chris Cahill at age 67, or ideally X number of years beforehand, and said, Chris, I have this law practice. I've been running my law practice for 30 years. It's generating $1 million a year. Hey, isn't that the way that I can bridge the gap to what Lisa and I need to comfortably be able to retire by age 72? So begs the question of, all right, how do you actually value a law practice? And that's a lot of what Senior Attorney Match does with our clients. And I'll share with everyone some really good news and some not so good news. So I always ask clients, like, where do you want to start? The not so good news or the good news? And actually, most people say, all right, hit me with the not so good news first. So the not so good news, but it's really not all that bad, is that currently there really are not reliable multiples for law practices. And the reason why is we look at this particular slide and we say, okay, there's 4 elements to valuing a law practice: the client list that Attorney Turner's developed, the referral source list that Attorney Turner's developed, the goodwill associated with his practice, and his own subject matter knowledge. Now, these are terrific, and this is why he continuously generates $1 million worth of revenues each year. The bad news, though, there is that it's all based on goodwill. Turner Law is not churning out widgets. It's not turning out things that we see at brick and mortar type stores, at restaurants, for any attorney that is doing business sales and sees the multiple in different industries. In law, it's really based upon the personal goodwill. So looking back at this particular slide with the value, what it comes down to, and this is the good news, okay, where Attorney Turner is at this point in his career. The value of Attorney Turner's practice, when you take these 4 elements, is you see these green lines here, is the future retained billings. For the right successor for Attorney Turner, the way that Senior Attorney Match promotes for attorneys to successfully transition their practices and monetize their practices is to either enter into an internal or an external plan that is internal within his law firm, and we'll talk about that in a few minutes, or joining a growing law firm where the payout to Attorney Turner is often an earn-out payable over time, a percentage of those future retained billings that are paid over a negotiated period of time. And just to satisfy the audience in terms of, okay, where does that wind up? And we will be showing that throughout the next series of slides. I'm finding that Attorney Turner should be able to realize a one-times revenue, ideally a one-times plus revenue. So Chris, that would be $1 million. We needed 1.3 to get to the finish line. And
Yep.
It's doable. It's very doable, but there are certain steps that Attorney Turner needs to take. And there are certain things that he needs to avoid and be wary of. So let's look at that first set of scenarios, which is what we call an internal transition. Okay, just to remind everyone, our fact pattern is that Attorney Turner has two associates that have typically, let's say, practiced with Attorney Turner for 10 plus years. In this model number one, and we'll be doing two models today. Model number one is an internal successor. And here we're talking about maintaining the status quo. That is, Attorney Turner will continue with his associates to generate that $1 million a year for the foreseeable future. Now, remember, he wanted to slow down at age 70. In this model, though, because often Attorney Turner, now could be different, but what I'm seeing and what we call attorneys like Attorney Turner in the smaller law firm setting, I refer to them as Papa Bears and Mama Bears. That is, they're the ones that are bringing in the porridge, the clients. They're the ones that have the referral sources. And as their practice grew, they brought in associates because the associates needed to do the work while Attorney Turner is out there bringing in the business. In the ideal world, Attorney Turner is introducing the clients and referral sources to his internal successors. They then think of a baton and a track race. They're picking up the baton. Attorney Turner at age 72 is then phasing out, practicing much less. In fact, is even fully retired, as we're seeing here. And Attorney Turner through age 76 is getting paid in that earnout. Now, why is the earnout only at $120,000 for 5 years? Unlike the other scenario that we'll show later on in the webinar, we're assuming that there are going to be clients that aren't going to stay with the internal successors, and he may not negotiate as competitive of a fee-sharing arrangement with his internal successors as he would if he went to the proverbial market and negotiated with several firms for Attorney Turner and often his associates to join. So Chris, 97%, that looks pretty good. Let's hear from your side about this scenario A.
Yeah, so it looks really, really good, to be honest, obviously, right? I mean, anytime we're above the green into above confidence zone, it's excellent. So in this model here, what we see is the income is really driving the savings capacity from age 67 to 72. We're assuming that he is saving all that's not being spent in the form of taxes and those living expenses that we discussed earlier. And then most importantly is that exit and the payout clearly helping offset those living expenses into retirement starting at age 73 to 76. So what we find in many instances here is that, you know, the longer one can keep their hands off of their piles, the savings that they've had, and allow it to grow, the more the probability of success rises, as we see here. So this is clearly a wonderful solution and opportunity. I would submit to you that that a model working out exactly like this is probably not likely going to happen. Having it go perfectly where the billables continue to stretch out just as illustrated and the buyout working so smoothly with the internal successor, there's a lot of risks that can come to the table. We can think of any number of them here. The successor not being equipped to do it, not wanting to do it after a period of time, maybe some health situations on either side of it that would prevent the numbers from materializing the way that they are illustrated here. So this is truly the best case scenario. And we're going to look at a couple of other scenarios as it relates to the plan of staying the course, what we call the status quo, and really stress testing these. So let's take a peek at the next model here.
So scenario B, Chris, this is the one that I observe most often.
As
That
do I.
is that is the same scenario, right? Attorney Turner, two associates, and where we just saw best case scenario. Here,
Mhm.
let's just take a look at this slide for a moment, because what's in some respects strange, and we'll explain this in a moment. Attorney Turner keeping up the pace of $1 million a year is getting more and more difficult
Yep.
as the years go by. So we're assuming that the income revenues into the firm are decreasing by
Mhm.
15% for years. And if we can just go back to that value slide for a moment, when we showed how Attorney Turner has these four elements to valuing a law practice. So in reality, as Attorney Turner is getting older, his clients are retiring. His referral sources are retiring. Number three, the goodwill. The goodwill is there, but there is a new player in the market, and that player introduced itself probably about 20 years ago, and then has really come on strong in the last 10 years. And that player is someone who people from age 3 years old to 103 knows, and it's Google. For as much goodwill as Attorney Turner has, and he may be the best business law attorney, the best teeny attorney in his community, when new clients are going to be looking for a T&E or a business law attorney, they are going straight to Google. And oftentimes, the senior attorney, and now we can go back to scenario B, what can explain why somebody who's otherwise really at the peak of their career in terms of subject matter knowledge and reputation and can charge a premium rate are losing the clients because he just didn't keep up with internet marketing strategies. So as a result, in reality, those revenues are going down. Now, the bad side of the revenues going down is also the fact that he wants to retain his associates and his staff.
Mhm.
Well, they're not readily coming to him and saying, "Hey, we'll take a haircut in our salaries." In fact, he's worried that they may bolt. And so he's actually, as revenues in the firm are going down, he's actually often giving raises. Or if he's not giving raises, then he's keeping them at the same levels. And all of a sudden, those internal successors that you're assuming are going to be able to take over your practice, they may actually leave at some point. And
Yep.
I'll just share with the audience, there's a podcast that Senior Attorney Match published earlier this year called The 5 Myths versus Realities for Succession Planning for Senior Attorneys. And several of those myths are that your internal successor is going to really wait around to
Mhm.
take over your practice. And as Chris alluded to, there could be an unforeseen departure of a partner, of an associate, and all of a sudden these numbers are going down. So long story short, and Chris, I'll turn it back over to you in just a moment. You'll see here that as this reality of less revenues and the potential for an associate or partner to actually leave the practice is making that plan much riskier.
Absolutely. I think the potential and more likely result in this status quo model is that the internal successor is going to make a decision to not stay, and that's heightened in the world that we live in today with COVID. I mean, so many people are making changes. So many people are contemplating their lives, where they live, what they're doing, where they want to be. And as a result, it's not surprising to see people make decisions that are contrary to what the conversations might have been prior. So there's any number of scenarios where we can see the internal successor leaving. But what it really means and translates into here for Bill and Lisa Turner and for their family is some difficult decisions and choices, right? So we've seen now the probability of success dropping from 97% to 77%. And the only change that we made in these models is the income capacity that Bill has, his corresponding savings capacity, and then the fact that in this model here, we see the internal successor saying, "This isn't working for me. Your practice isn't worth what you thought it was." And they're either going to go to another firm or they're going to say, "I'm going to go set up a shop right next door. See you later." And that happens too, as you all know. So what happens here, unfortunately, is that tail, that buyout that allowed Bill and Lisa to keep their hands off of their piles otherwise is now gone. So at age 72, they need to start hitting their assets for retirement purposes sooner than they would have otherwise. And as a result, these assets coming out of taxable accounts, IRAs, 401ks, subject to income taxation, and it really depresses that probability of success from 97%, which is very, very comfortable, to 77%, which I would suggest is less so. So this is kind of getting them to the point where they need to start making decisions about, are we going to continue to spend like we did? Couldn't we travel like we want to? Should we continue, and can we continue to help the family as much as we want to and have? So these are the hard decisions that will come from this scenario.
Right. And before we go on to the next scenario, just also add the other difficult decision. If they come to you, Chris, and they don't want to have to tap into that, I think the difficult conversation that you'll have to have with them is to turn to Bill and say, Bill, you wanted to retire at 72.
Yep.
That just got pushed out to 75.
Absolutely.
Because even though he wants to retire, working longer, and by the way, that still means 5+ days a week, a tremendous amount of stress, less time with grandchildren, but may need to do it because they need the income. So we promise we'll get back to sunny times, but we're just going to go to our last scenario, because this is also something that doesn't happen, luckily, doesn't happen often at all, but it can happen. And that's this last scenario C, which we call the worst case scenario, which is a random Tuesday event, which is an unforeseen physical or mental health incident. If we remember at the outset of this, we explained that lawyers aren't selling widgets. It's all based upon the personal goodwill of an attorney's practice. Unfortunately, when a senior attorney can no longer practice, the ability to sell the law practice, and we won't touch upon it much during this webinar today, but there is a mechanism in the professional rules of conduct in every state. Massachusetts and every state has adopted a version of the ABA's recommended Rule 1.17 in the professional rules of conduct for how to sell a law practice. Senior Attorney Match has only done that to date, unfortunately, when working with estates of law firms. And when it's an estate, because the attorney is not there to transition the law practice, it is a very, very low number. And Chris, I think it's important for you as as a financial advisor, if you were meeting with Bill and Lisa, whether it's at age 67, early in their 60s, there are insurance products that they could be investing in. So God forbid a random Tuesday event like this happens, so their family can be protected.
Certainly. And this is where early planning makes all the difference. So hopefully many of you out in the audience today are in your early 50s, late 40s, and just trying to be proactive, and that's wonderful. And you're not waiting till, late 60s, early 70s, which we see, quite frankly, too often. So you're right, Jeremy. Planning up front is really important. So the more that you save when you're younger, the better off your probability of being able to retire successfully. It's obvious. But the reality is that there are certain mechanisms and things that you need to do in order to minimize your personal risks. Those things are very simply making sure that you have appropriate disability/income protection. It's amazing to me how few attorneys truly have that locked up and figured out. I sell a lot of disability insurance in this marketplace for that reason, and it's really, really important. So making sure that you're going to cover at least 60% of your taxable income is critical. Obviously, providing appropriate life insurance for your family to provide for your spouse, your children, your grandchildren, etc., is huge. And then the other is long-term care insurance. Clearly, an overlooked area for many folks, but making sure that you have appropriate coverage to pay for those risks of having an Alzheimer's, a dementia event, or some other care need, and shifting the risk to an insurance carrier is huge. So theoretically, our clients plan for that well in advance. This model here shows somebody that did not and had something happen to them at the age of 70. Income was progressing well, so we're going along that first model where everything is good. Something happens, the successor doesn't materialize, they're now at home, unable to work, and as a result, they're having to hit their assets more, and the probability of success has gone dramatically down. So this is this is really impacting the Turner household pretty significantly at this point. And that lever that you just referenced on the prior slide of the depreciating asset where he can work more is not possible. It does not exist. So now we're really talking about dramatically reducing expenses and lifestyle.
Great. So let's recap the financial model number 1, and then we'll go right into model number 2. So Chris, you want to hit the pros?
Sure. So it's obvious. I mean, people like status quo. They don't like to change. So it's comfortable. Attorney Turner knows what he's got in his practice. He knows his people. He knows how to get to the office, at 6 o'clock in the morning when he's getting up and going. He remains in control of the Turner law firm. And, that first model, if all goes well, from 67 to 72 continues to generate the money, and he's able to transition it. Real high probability of success. So that's attractive and appealing. I would just simply say it's not necessarily a guarantee.
Great. And in terms of the cons, even in that best case scenario, Attorney Turner is still working typically 5+ days a week and working through age 72. There's the possibility of the Random Tuesday event that we described, and there's that lowering in revenues while expenses are at least staying the same, if not increasing. And by the way, I'll make an exception to our rule of doing Q&A at the end, because one of the people in the audience asked the question of, are there steps that Attorney Turner could take, or really any attorney with an internal successor can take to mitigate those concerns about the internal successor leaving? And there, I can't emphasize enough, and if we can put back up that link to that podcast episode, that talking with your internal successor is so important. A big, huge myth is that if a senior attorney approaches their internal successor and asks them what are their thoughts about succeeding to owning the practice, or as we get into the next financial scenario of potentially joining a firm, a huge myth is that the internal successor is then automatically going to leave. And then the senior attorney is really, in a hard way because the presumed internal successor has just left. In my experience, it's a total myth, because that internal successor depends on the senior attorney for their financial well-being. They're writing the checks, and the internal successor typically doesn't have a significant enough book of business to go to another law firm. So just to answer that question, and we can address it more during the Q&A, totally promote is having a sit down with the internal successor and just have a heart-to-heart, and they'll appreciate it. And also involve an intermediary, whether that senior attorney match, financial planner such as Chris, someone else if the senior attorney is not comfortable, but have the conversation to avoid the Random Tuesday.
Yeah, and I would agree with you completely on that, Jeremy, because it's on the mind of the potential successor as well. As a young attorney or a maturing attorney, they're trying to figure out what their future holds and where their place in the world is. So as Bill is aging in his career, his associates sitting in the office next door to him, looking at Bill aging, looking at the clients aging, and wondering, what's the plan here? And they might be a little shy to ask for fear of maybe overstepping their relationship. But I think it's incumbent upon Bill to bring it to that successor and have that conversation in order to really open it up and have that possibility of getting that 97%. If they don't have that conversation, that's not going to happen, because that successor will bolt at some point for any number of reasons.
Chris is right, and and often, of course, the most inopportune time. Hence why we call it a Random Tuesday. So now let's look at the second option for Attorney Turner, and this is actually the option that Senior Attorney Match has been promoting since 2013. I really see promoting as hundreds, thousands of boomer attorneys are considering, how to get the most value out of their practices and transition to the right successor. So this one is called Join a Growing Law Firm. So as we know, Attorney Turner has annual billings of $1 million. Okay, and just this review of his major assets, which are himself and his 2 associates, as well as, of course, those clients and referral sources. I want us to keep our eye on the ball in terms of how many annual billable hours that Attorney Turner bills per year, that 1143 number. While he's running Turner Law, He's billing those out, and then he's spending a significant number of hours of managing the office. He's the one that deals with the copy machine when it breaks and needs to be replaced, when the paralegal quits, when you have to negotiate a new lease. All these kinds of things are significant time drags on Attorney Turner. So now we'll go to the next slide. And we just want to give you a sense, okay, of what a financial arrangement with a growing law firm could be. Now, this is not indicative of all firms. This is indicative, though, of the type of arrangements that Senior Attorney Match negotiates. So Attorney Turner and his two associates, sometimes his support staff. Hardest thing about what I have to do sometimes is that the support staff does not always join together with the senior attorney and the associates. He joins, and he's made an arrangement with this growing law firm that they will pay him 50% of the collections on matters that he originates and bills. He's going to get 30% of the collections on matters that he generates and doesn't work on. They're going to pay him $20,000 in fringe benefits because the law firm had typically paid for certain business-related items that the growing law firm matches. That's that additional $20,000. And then the firm has agreed that when he retires, when there's a trigger event for retirement, that the firm is going to pay Attorney Turner 25% on all the matters attributable to him for a period of 5 years. So now we'll go through a similar A through C like we did when he's running Turner Law. In scenario A, which is another best case scenario, here we have Attorney Turner. Okay, so we're assuming the same amount of revenues are coming in because he has successfully transitioned those clients and referral sources. He's informed them that he's joined this new law firm. This law firm does the same type of practice that he does: business law, real estate, T&E. They also do the areas that he used to refer business out to, so he can capture those revenues instead of referring them to other lawyers. So here we have Attorney Turner working at ages 67, 68, 69. He's actually making more money, $430,000 versus the $400,000, primarily because of that capture, okay, of the work that he used to refer out. He's retiring at age 70 versus age 72, and he's receiving $200,000 a year for ages 70 through 74. For anybody doing the math out there, what we're assuming is that 25%, he's not getting 25% of $1 million. We're figuring that there was some business that is going to be lost by joining the new firm. So he's making that 25% on $800,000 over 5 years, though. Chris, that gets him to the $1 million amount, and he was able to significantly retire at age 70.
Right, and this is a wonderful solution for Bill, to be honest, because to your point, it allows him to remove that headache of the administrative components, the HR, the negotiating of leases, the shoveling of the sidewalks, all of that stuff that he had to handle in the day-to-day practice that kept him away from his passion, which is practicing law, right? So in this model, what we see is that $430,000 a year of income for 3 years, works real hard. This really, really depends upon him being able to transition those clients into the firm. And what then happens here is he gets to go put his feet in the sand, wherever that is, and relax, because he's going to capture that billable coming off for those 5 years into retirement. And that is just such a weight off of his shoulders that it just really impacts him and the family in a positive way. So the probability of success is excellent here still. And what I would submit is that, the clients, along with the staff, is going to be happy because there's now a plan in place, a real plan. There's a firm that Bill's joining. It's a quality firm. It's a firm with a name that people know and respect and like. And they now know, as staff and associates and as clients, particularly important for the clients, to see, hey, there's a plan here, because you know what? The clients are sitting around wondering, how long is Bill going to keep doing this? He's not as young as he used to be. And at some point they might say, I want to work with somebody that's got a plan in place. So this answers those concerns really, really well. So this scenario here is clearly the best case in this modeling. But it's also just really comforting to Bill and Lisa, because they now can retire a whole lot earlier than they would have otherwise.
Great. And if we can just go back to that value slide again. because just to make the point that Chris was saying, we talked about before with Turner Law and the introduction of Google as a player, that he's going to have depreciating value as he's running Turner Law. To Chris's point, when Attorney Turner is joining the growing law firm and he's now able to introduce to his clients and referral sources several 40-somethings, early 50-somethings, 30-somethings that know that they can capably, competently, zealously continue to represent his clients, there is not a depreciation in that value. In fact, there's an acceleration in that value. I'm working with a client right now. She will be spending the next 10 months introducing her clients that she's developed over the course of a generation to the lawyers at the firm that she joined. And also, Chris, to your point about the relief of no longer having to carry those administrative costs. It's actually at every closing that I've had to date, maybe not everyone, but almost everyone, after literally the ink dries, the first statement that the senior attorney will say is, I am so glad I am never going to have to write a rent check ever again or worry about payroll. Because instead, what they're focusing on is what they enjoy doing. And whether that is working on cases, whether that's developing business, whether that's even tutoring younger attorneys. Exactly. It's a tremendous value, so many values that senior attorneys can offer as compared to negotiating a new copier lease that they can't believe that they're signing off on.
No doubt. So let's take a look at the next model here, Jeremy, what we call the medium case scenario. So here, walk us through the fact pattern, and then we can address the impact of the models.
Same fact pattern. Attorney Turner and his associates, they join the firm, and the only real significant difference here, Chris, and this is a hard one for senior attorneys, is giving up control.
Yep.
Right. That is, join a firm, and you're still calling your clients, say, you know what, I joined the XYZ firm, but still call me. I'm still your attorney.
They hoard it,
right? And when that happens, ultimately the transition of the clients is not as successful. The good news is Attorney Turner's not going back to this whole copier lease metaphor. He's not worrying about copier leases and making payroll and all of that. But because he did not successfully transition the clients as well as he could have, look what happened in that tail period.
Yep.
Okay?
Yeah, exactly. I mean, it impacts the models slightly. Anytime I see 92 probability of success in these models, I'm very, very happy. So it's not going to break the family in any way, shape, or form, truly. But, you know, Bill needs to understand that going through this process, his job now is to move the clients into the new firm, continue to work with them, and hand them off so that he can exit in that 3-year time period. That's his primary objective. And for an attorney that's thinking otherwise, that they just continue to want to do it, call me, that are not planning on hanging up the cleats for a athletic metaphor, you know, that's where they can get themselves into trouble.
But luckily it's not all that much trouble. And you know, we now have introduced what we call integration consulting, because when a senior attorney like Bill Turner joins this firm, to integrate Bill and his clients and referral sources into the firm is really huge, because essentially Bill was the class president of Turner Law for 20 years. He reelected himself, okay? Yep. But he was class president. Now he comes into this new firm. He's a freshman, you know, and basically like a new high school, but he's that freshman that's the all-star on the starting five. And if he integrates into that team, they all win.
No doubt.
So let's go to scenario C. So in this model, of course, you have to plan for the fact that what happens if it doesn't work? Okay, we could do all the due diligence in the world and figure that on paper and after multiple meetings, Attorney Turner and the firm that he joins is going to be the right match. He's going to be there for the rest of his career, but things happen. Okay, I could use an expletive. We won't, but things happen. And after year 2 here, we're assuming that Attorney Turner leaves the growing law firm. But the thing is, Chris, we're still at 91% here.
Yep. Well, and it's due in large part to the incoming revenue, as I discussed in that first model, right? If we can keep our hands off the piles, allow it to continue to grow and be deferred, tax deferred in those IRAs and 401ks. I mean, to the extent that you're getting 240, 220, 190, 160, that's in large part covering a large chunk of those living expenses that they need. And then, of course, having that little tail here of the 75, that still provides a big lift under the financial models for the Turners. So I'm still very, very comfortable with this here. This really is dependent upon the quality of the document executed between Bill and the firm to make sure that year 3 here at age 69, that he's going to get paid that amount of money going forward, and still be able to get to this 91% probability of success.
That's right. And so just to go a little bit into the weeds, the agreements that we'll draft will provide for, if there is a divorce, there's a breakup, then clients that remain are typically subject still to the terms of the deal and the fee sharing. As lawyers will know on the webinar, there are no restrictive covenants permitted between attorneys. Very cognizant of the rules of professional responsibility, how they work in terms of breakups. There is an allowance for restrictive covenants when there's a sale of a law firm. But the reason why we stay in that higher percentage is because Attorney Turner would have done the hard work to really organize his office and his business, so that if there is a breakup, and yes, we've had only 2 to date, but in one of those breakups, one attorney wound up retiring. The other one, because he was so well organized through the original process, we knew exactly where we could identify and how we could identify a different firm for him to join. He did join it, and it's been a terrific second marriage. Before we recap, there was another question from the audience about, how do you choose the right firm? And we'll just spend just a moment on that. Senior Attorney Match has a whole segment to we talk about, we design and we implement succession plans. So as part of the design phase, we have something that we call the next step process. So in our next step process, we determine the types of firms and identify firms for senior attorneys, which very typically are firms that are already practicing in the same practice areas and often in the same geographic area as Attorney Turner. So here, looking for attorneys that practice business law, real estate law, and T&E, or at least 2 out of the 3. And we're really looking for the mirror image of Attorney Turner from 20 to 30 years ago. There's a huge cultural component that finding people that you want to work with, that you like, that your clients are going to like. Your clients depend on you. And you want to find successors that you're going to feel very comfortable as the senior attorney, here Attorney Turner, feeling very comfortable working with the lawyers that Attorney Turner has joined. So Chris, why don't we recap, and then we can go into Q&A.
Certainly. So Jeremy, let's flip it around here. Why don't you hit the pros, and then I'll address the cons.
Great.
I do want to come back to that question after the end on this, because I think it's a really important one about fit.
I agree. So in terms of the pros on joining a growing law firm, the relief one, is just no more overhead, no office management or minimal office management responsibilities. The second one is maintain annual income, while you are transitioning clients and referral sources to the growing law firm. And by the way, it's fascinating. For so many business owners that never really took a regular check, it's interesting, fascinating, relieving to actually get a check every 2 weeks. And it's all typically subject to a formula, but to actually be on payroll is an interesting experience for many of our clients. And here, like Attorney Turner, can often retire, or at least be able to retire, right? When we were talking before, when he's running Turner Law, I mean, every January 1st, when Attorney Turner is waking up, he's thinking to himself, is this the year that I can retire? When you're joining a growing law firm, you actually have that in an agreement. Now, granted, things can change, but we've negotiated. He's going to retire by a certain age. We've negotiated the cash flow, and just recalling that value slide. We don't need to go to it now, but recalling the value slide, he's got a plan in place to transition those 3 valuable components of his firm: clients, referral sources, and the goodwill. So let's hear about the cons.
So obviously, it's all about the integration, right? I mean, making sure that Attorney Turner matches with XYZ firm, and that the staff does as well, and the clients, and the referral sources, and those things are potential risks, and there's a lot of work involved in that. That would probably be Bill's full-time job for a period of time. Clearly a risk is that the revenues just don't materialize as anticipated. That is the biggest thing. That's the thing that will keep Bill up at night for sure, at least for the first several months of the transition. And that will impact his capacity to generate the income that we've seen in these three models. So if it doesn't materialize as indicated, then clearly the models are going to change and be different. And then the biggest one, obviously, Bill's been a bit of a lone wolf out on the range by himself. And now he's going to be working in a firm, and he's going to need to play well with others. And, working for/with others can be difficult for many attorneys that are solos or in very, very small shops. And, Jeremy's seen it. I've seen it. We've all seen it where people just don't play well with others. But that's a big risk, but not one that's insurmountable. Again, assuming that there's no real personality issues. I mean, if Jeremy or I was working with an attorney and we sensed that their personality had a serious edge to it that made it difficult to envision this person being in a traditional office that we know and we work with, we would talk about that. We would probably get some sort of coaching and guidance to help smooth that transition, because if he gets in there and it's just abrasive, that's not going to work for anybody. So that, I think, covers the pros and the cons and the recap. We're going to transition here. We're now almost 50 minutes in to address more of the questions. But before we do, I wanted to just take a quick moment, Jeremy, and spin back to the question that the audience member asked about the right fit. So that is just such a huge component to what Jeremy does, what I do when I help clients transition their practices or move from firm to firm. It's all about the culture, and it's all about knowing, really understanding what the attorney's practice looks like, what their business looks like, what their clients look like, and what sort of folks that they'll mesh well with. Many of these firms in and around the area that Jeremy works with, that I work with very closely, we know them well. We know what that firm culture is. They're hard charging. They're in, bright and early. They're working real late. Maybe they're a little bit more laid back. Whatever it may be, we really take strives to know what the firm is like so that we can make sure that Bill is in the best position to have the most likelihood of success going forward. Because if you put somebody in a hard charging environment where they're a little bit more laid back or vice versa, it's a recipe for disaster.
Thank you, Chris. Okay, so we encourage people to put questions in the chat, and we appreciate the questions that are coming through. Our next question is about payment, and this comes up a lot, which is it reasonable to anticipate both a one-time payment for goodwill and then a percentage of referred business thereafter? So Karen, thank you for that question. So some tough news here, okay, but it shouldn't really be that surprising. And again, if we can just go back to the value slide. The tough news is that it is very difficult for a bank to lend on goodwill. Okay, because if we think about all the attorneys that are watching this, what are the UCC1 assets that a bank can list in that financing statement? Attorneys typically do not have much in terms of hard assets, and yes, accounts receivables are something that a bank can lend upon. But again, if we look at these green arrows, it's the future retained billings. So a buyer and a bank are very hesitant to lay out significant money without knowing that the clients are going to actually transition over to the buyer's firm. And a buyer, a growing firm, however we want to call the firm that succeeds to a senior attorney, an internal sale, okay, are much more comfortable saying, okay, senior attorney, you have these 4 elements of your value, if they produce, will produce. And that's why I'm often finding and structuring that the payments not include an upfront payment. It's just the reality is that there's typically not an upfront payment and that the payments are done over time. There are exceptions though. Okay, and those exceptions can be, and it can be a low 6-figure amount. Using Attorney Turner as the example here, $1 million. I would think that perhaps he could receive a low 6-figure amount, and often that's based upon what the actual accounts receivables are. Side note on personal injury law attorneys, if there are any personal injury law attorneys following this today, is that personal injury law attorneys actually have real inventory with their cases and have a good sense of what those value of those cases are. And there's where I've seen upfront money to be available, even from a bank, based upon the value of what those cases should generate over the next 2 to 5 years, typically in a personal injury lawyer's practice.
Excellent point. And you know, personal injury attorneys are certainly their own breed. I mean, those folks live different lives than a corporate attorney. So modeling for PI attorneys, litigators is totally different from my perspective than somebody that's just got a traditional transactional practice that churns out the business each year. So it's interesting to think of that as well.
Good. So the next question, and this is something we didn't address, but this is something that I hear all the time, which is, can't I just, if I'm a senior attorney, I'm Attorney Turner, can't I just recruit an attorney from a medium-sized or large or large law firm that has an 1,800, 2,000 hour plus annual billable hour requirement? They never see their kids and they don't see their spouse. My practice is just a turnkey operation ready for that attorney to take over. That's often in the first 5 minutes. We run a program called the Next Step Workshop, where we in 90 minutes we go over what the timeline and what the plan is for what a senior attorney wants to do. And that's typically almost right out of the gate the question: what can we identify what a client of mine calls a kid? We actually call that the most risky option for a senior attorney to pursue. And the reasons are that there's a finite number of kids anyhow. And more among Generation X, millennials, and I really think future generations are markedly different than the boomer generation. That the boomer generation had no problem hanging out their shingles.
Right. They're less entrepreneurial for sure.
Exactly. And the Xers and millennials often want a job. So there, your pool of candidates is low. Also, those candidates that are going to be leaving because they want a job, they're getting as your competition. The competition of the senior attorney are other law firms, and they're typically medium and large size law firms. Then if a kid actually joins your firm and stays with you for X number of years, that kid is going to be getting calls from recruiters all the time. Come back to the city. This firm wants you. That firm wants you. And then using Attorney Turner, who was 67 or 68 when he would have recruited a kid, that kid then comes back at age 70 and says, you know what? I'm really sorry. Had to make a decision for me and my family. Going back to Boston. And you know what's also bad about that? He's taking some of your clients and referral sources because they want to work with the kid. So it can happen. I have helped attorneys bring in a kid, but it's very risky.
And you just don't know what the reality of working with that individual is either. At least in the internal successor, you've worked with this person for a period of time. You know their character and their capacity. Bringing somebody in from the outside is risky because you just don't know what you're getting truly.
Great. And as a next question, and Chris, we've concentrated so much in this webinar on really a smaller firm attorney, right? Mm-hmm. Attorney Turner, 3 attorneys altogether. How does this apply? You work with attorneys throughout the Northeast, often in medium and larger sized firms. Yep. What about the attorney that's working in a significant law firm? 20 plus, 50 plus attorneys. How does this fit for them?
Yeah, so I mean, the reality is that these attorneys still need to plan for their future And even at bigger firms, I've had clients at AmLaw 100 firms that have just had enough of the rat race, and they've realized that, you know, they need to make a change. Some of the biggest firms have these up and outs at age 65, for instance. And, you know, if your situation is such that you haven't planned appropriately, they're going to force a retirement on you, even if you want to go to age 72. So whether you like it or not, you're going to need to make a move. So from our perspective, making sure that they're focused on planning, that they really have spent the time to understand what their goals, their objectives, their wants and dreams are for their business and for their family is huge. And, you know, we spend a lot of time working with clients on that and helping them identify, not only through the financial modeling perspective, but just through really getting to know them, what's important to them about their wealth management, their planning, and their family. And then from there, we help them work with people like yourself, Jeremy, or simply transition. They might have an offer from another firm, and they might come to us and say, you know, XYZ firm has offered me this. I like them. I feel comfortable with them. What does it mean for my modeling? How does it change? Does it make it go up or down? And we'll run it through the system, and we'll help them make the decision. So certainly see that quite a bit.
Great. And I think also, Chris, one thing that lawyers don't recognize, and I'll mention two things when it comes to medium and large sized firms. One thing they don't recognize is I think what you were mentioning before, which is that they have options.
Mm-hmm.
Okay, you could have been at a firm for 20, 25 years, and you and I have talked about this. The T&E lawyer who the senior partners come down and say, okay, we're got to raise your rates. And you were at $900 an hour, let's just say, we're going to raise your rates to $1,200 an hour.
Finding a client that wants to pay that, right?
Right, exactly. And so what you're saying is correct. That is, the market can only bear so much.
Mm-hmm.
Now, if that attorney is billing out at $900 an hour, well, heck, at $600 or $700 an hour, even $500 an hour at a boutique T&E firm, you know, somewhere out in the suburbs, that would be psyched to start working with that attorney's clients. I mean, that is a hero opportunity.
And they can make more personal money and have a better lifestyle. So I agree with you that we do see that quite a bit. You're right.
Great. And so we're getting another question about different valuation methods for how do you value a law practice. And so I certainly, throughout the course of this webinar, I will really stick by, because I've been doing this now for almost 10 years on the valuation model, and we can go back to that value slide. There are different approaches to valuing a law firm, like valuing a business. Okay, in terms of going to an accountant or a valuation specialist. But I am just absolutely convinced that when it comes to valuing any law firm, and here the question was, are there different scenarios for valuing firms with more of a revolving door practice, like family law? Okay, and in my opinion, it all comes back down to this. Okay, the goodwill of what the senior attorney brings to the table is the ability to generate clients and referral sources of the senior attorney to transition internally or externally, and then produce the ongoing revenues, not depreciate, but accelerate, heading towards those final years of practice. That's the proof in the pudding for what the value is. It's the future retained billings attributable to these 3 points.
Excellent.
Great. Wondering if there are any other questions. Otherwise, we can start wrapping up. We've got about 5 or so more minutes on Q&A.
And remember, this will be posted live, and or posted out to you, so you can watch it and review it later, and share it with your colleagues to the extent that you feel a need on that part. So you'll have it shortly.
Terrific. Well, we very much want to thank Mass Lawyers Weekly for all of its efforts to host today's program, in particular Susan Bocamazzo and Scott Ziegler at Mass Lawyers Weekly. Chris, I really want to thank you as well It's been an absolute pleasure presenting with you, preparing with you. Your focus on lawyers on a national basis. You are a lawyer. You understand small, medium, and large-sized firms. You understand attorneys like Attorney Turner, and you understand attorneys that are working at medium and large-sized firms. And just can't recommend enough for lawyers that want to do financial planning. You should be working with people that understand what you go through on a day in, day out, year in, year out basis. Chris, it's been a real pleasure.
Thank you, Jeremy, and I feel the same. It's been wonderful putting this together with you, and I certainly want to thank the folks over at Lawyers Weekly. Great job here, and to the extent that there's specific questions that we didn't have a chance to address here, we'll do our best to follow up with you and answer those to the extent that we can. And before we end, I just had two things that I wanted to say. As it relates to financial planning and retirement planning for lawyers, just take a moment and think, how would your life be different if you knew that your planning was all set? What sort of peace of mind would that provide to you and your family? So as you think about what we've talked about here today, those are really important questions, because I think it would provide you with the clarity and the comfort to know that you've really gotten yourself all set. So really appreciate it. Thank you all for your time today. Jeremy, is always a pleasure. Andrew, Susan, Scott, thank you. And we'll talk to you all soon.
And actually, you just referenced Andrew. So there's an unseen person that we really also want to give kudos to, and that's Andrew Penziner. Andrew runs a company called Motivity Video, which is Massachusetts-based. And Andrew has been orchestrating the entire webinar today. We're in a changing world. We are, as we all know, we have been thrust into this Zoom world. We're actually using a different program called StreamYard. And for anyone that is looking for video services, whether they're doing webinars, want to introduce video to their websites, they will also do really well by themselves, to contact Motivity Video and Andrew Penziner. So you have our contact information. We would be very happy to continue the conversation with any of you, and we appreciate everybody's time. Have a great rest of the day. Thank you.
Thank you. Be well.